on Law and Crime.
Back live in the trial of Lindsay Parton, the babysitter who's been accused of killing 3-year-old Hannah Weshy. The question is, the injuries sustained by this young girl, were they the result of someone hitting her? Was it Miss Parton? Or was it, in fact, from her falling, allegedly, 2 times in the days before she ultimately collapsed and succumbed to her wounds? Right now on the stand is Dr. Michael Yang. He's a pediatric ophthalmologist who's discussing more about the injuries sustained by this young girl. Let's go live and we'll learn more.
The retina, you can see the optic nerve on the right side, and that looks, nice and clear. And then you have normal retina. This little depression in the middle is what we call the fovea. It's the sharpest point of the vision. And then you're looking at blood vessels coming out from the optic nerve. And again, the retina is relatively transparent, so you're actually seeing through it to another layer of the eye called the choroid. So these are the things that we kind of look for.
All right. State's Exhibit 23.
So this is the piece of equipment that I was referring to earlier. It's called the indirect ophthalmoscope. This is the examiner. You can see he's wearing a hat, and then this device comes down over his eyes, and light is shined into the eye, and an image is reflected back, and then we can see that image. So you're holding this lens here in front of you, shining it and focusing into the inside of the eye. That allows you to see the details that I showed in the previous photograph. We also look left and right, look as far towards the equator of the eye as possible. We don't have just the view that I showed in the previous photograph.
All right. And State's Exhibit 24.
So this is a ret cam.
Okay, so we're going to jump out of this right now. It's more of a lecture. I mean, this is like an advanced course on retina study. And really, the reason this is important is because we know that Hannah's face, according to this doctor, was very swollen. He said that she had eyelid swelling, blood discoloration, especially in the upper left eye. So we're kind of learning more about the injuries sustained by this young girl. Dan, I mean, the thing is, does the timeline make sense to you? I mean, all these injuries that she sustained, and she was only at Parton's house for a few minutes before Parton calls Jason Weshy and says Hannah collapsed. Or do you think that this is a result of injuries from days before?
Well, it's still unclear, and that's going to be the crux of this trial. Could injuries that have happened before at the hands of this defendant resurfaced or been exacerbated by something she did on another day? And the defendant's going to say that she wasn't in a position to cause these injuries, if they are injuries from an intentional infliction of force versus an accident. And it's really important what this pediatric ophthalmologist is saying about how these injuries were caused. He's describing them. He's going about it in a methodical way, and he'll probably reach a conclusion at the end that we assume would be consistent with the prosecution, since he's a prosecution witness.
You know, and it should also be noted, what you're seeing right now, this is Hannah's eye that they're actually looking at. It's a really horrific case, but one of the things we got a sense of from yesterday was, at least the defense was saying, that the behavior of the father was questionable. They even seemed to be suggesting that when EMTs came to the scene, was he shaking his daughter or not? You know, and were there more injuries caused by people that should be considered here? Was it not just from the father, but maybe when the EMTs were trying to transport her, certain injuries were caused there? You think if they raise enough of that, they could have a reasonable doubt here?
That's the goal, and it is a heartbreaking case. Obviously, we see the victim there who, was killed or died through some injury at 3 years old. Now, as far as the father shaking her, there was some different wording used by the witness there. I think shaking was used first, and then that word was changed a little bit later in testimony to nudging or something less violent as shaking. So that really matters, how it's perceived by the jury and how it's described.
Right. Yeah, we're still in the beginning parts of this, trying to understand what happened to Hannah. Let's jump back live. Again, this is Dr. Michael Young.
In the jelly, or in the space between that jelly and the retina itself, you've got these dot blot hemorrhages that are intraretinal, and then there are some flame hemorrhages here. Just sounds just like that. It's like a flame spot, a flame streak that would be considered consistent with neurofibrillar hemorrhages.
Doctor, I believe we looked at an exhibit of what a normal eye looks like, and it doesn't have hemorrhages like you've described.
Correct.
Is that correct? And it says posterior pole. What does that mean?
Well, if you think of the eye like a globe, you have the North Pole, you have the South Pole. So we kind of talk about this general back area as the posterior pole.
All right.
Okay.
State's Exhibit 30. Let me clear that off.
Yeah, so I've labeled this as the temporal aspect. Temporal just meaning that's closer to the ear. So if it's in the patient's right eye, I'd be looking towards the side part of the inside of the eye, closer to the ear. And this is showing that the hemorrhages go out pretty far here. You can see this would be the furthest extent that we could get with the camera, and that's pretty far out. You can see some of the vitreous hemorrhages. You don't actually see the optic nerve, which is probably somewhere here. So this would be potentially like the center of vision here, and so you can see that we're getting further out. And so it's showing that there's more hemorrhages further out than what we saw earlier.
State's Exhibit 31.
So this is an attempt to look at the nasal retina here. And so again,
What does
here,
that mean, nasal?
Oh, so more towards the nose.
Okay.
So you have temporal and you have medial or nasal. So more towards the nose. So we're now directing the indirect ophthalmoscope. So we're looking more towards this side of the retina. And I'm sorry, this is the retcam, but it's corresponding to what I would be trying to see with my indirect ophthalmoscope. And again, here you have the optic nerve. You have those same hemorrhages that help you to identify where you are relative to the other picture. And this would be close to the center of vision. And there's still hemorrhages out here that you can see. And generally speaking, we can see further out with our indirect ophthalmoscope than the camera can actually take pictures.
All right.
And this is superior.
This is State's Exhibit 32 for the record.
Superior just means we're looking up now. Okay, and here again is the optic nerve from the previous, if you want to correlate this with the previous photograph. And this is probably the center of vision there. And so we're looking more periphery. You can see that the bleeding is pretty extensive and continues to go further beyond the original view. Yeah,
33.
Sorry, and then this is the inferior view, so you're looking down. And again, for reference, here's the optic nerve, here's the vitreous hemorrhage, and then the bleeding continues beyond that.
Okay, we're getting very in detail here about the injuries sustained by this young girl, but we're learning a lot. And the question is, was this an accident? Was this a fall? Or was this an attack? We'll take a quick break. We'll be right back. live in Ohio in the Lindsay Parton case, the babysitter accused of killing 3-year-old Hannah Weshy. Dr. Michael Young, a pediatric ophthalmologist who's discussing hemorrhages to the eye of Hannah that's associated with non-accidental trauma, maybe abuse, is discussing her injuries right now. Let's go live.
So it could be both, but primarily it's thought to be the shaking. The patients who have just purely impact are much less to have hemorrhages, and the number of hemorrhages are much smaller, and they typically are not in all 3 layers or extensive like this. We see patients who've gone in through motor vehicle accidents, and as long as the eye itself is not directly traumatized severely, the mere fact that they have an impact on their head or something like that doesn't produce these kinds of hemorrhages.
So, doctor, I know we've talked about it, but I'm going to ask you now regarding this non-accidental trauma, abusive head trauma. Based upon your training, education, and experience, and to a reasonable degree of medical certainty, what is your opinion as to the cause of the injuries that you saw in Hannah's eyes?
Yeah, my medical opinion is that it's due to abusive head trauma.
If I may have just a moment.
Take your time. Well, Dan, that's what we were waiting for, the main conclusion. He believes this is abuse. What do you make of it?
Well, that's really significant. He comes off in a very credible way. He has a lot of authority. He has a lot of experience. And he said abusive head trauma caused this injury. Now, the defense can either dispute that with other expert testimony, or they could say the abusive head trauma was caused by somebody else. But it certainly seems it won't fly for the defense to just say this girl fell and it was an accident.
That's a good point. It seems hard for them to argue this was an accident and she fell. Why didn't they center their attention on other people who might have done this as opposed to the defendant? Because it seems their best argument is that this girl was in her care and custody for only a few minutes before she calls the girl's father. Why not capitalize on that? Couldn't this flip on them in the sense they tell the jury, well, it might be from a fall, but wait, maybe it's somebody else. I mean, they can't go too many ways.
That's a good point, but if you look at it from the defense perspective, let's say they're telling the truth. Let's say she really did just receive this girl and she doesn't know how she got injured. Then she might say, oh, I remember she did fall yesterday, but maybe she was with somebody else. And she may not really know what the answer is for who caused the injury if the defense is telling the truth. So that's why they may be speculating about different things.
The defense attorney in this case, in opening statement, said this, the evidence will show that Hannah's father brought her into the garage with a blanket over her head and her coat hood up, handed her to Parton, and he left. And within 30 seconds, a minute, she's calling him, the child is unconscious. If that's true, that's odd. I mean, why would he deliver his child in that way?
Right, if that's true, and if there wasn't enough time for this defendant to cause abusive head trauma in that time period after receiving this girl from her father, then that would be good for the defense in terms of establishing at least reasonable doubt. So we may hear the father testify about what really happened when he delivered his girl to this defendant.
One thing to note, we believe that Lindsay Parton, the defendant, is going to take the stand and testify. What do you think that'll be like?
That's going to be the key part of this case because she's going to have to give a version of events that's believable to the jury. She'll be cross-examined about how these injuries might have been caused, and that's always difficult for any defendant. But it might make sense in a case like this where she has to give some version of events, unless, and sometimes they say someone's going to testify, then they don't testify if the defense feels they've made out reasonable doubt through just going after other witnesses. So we don't know if she's going to testify, but it would certainly be very interesting and very important for this case, obviously.
What's the best scenario for her testifying? I mean, what would be the thing? Let me use a standard now. What would be the James Scandarito version of testifying? Because I'm referencing, he took the stand and he got off for murder. But here, what would be the best thing for her to articulate on the stand?
Well, first of all, she'd want to testify about how she took care of this girl, how she babysat for her, how she loved her, how she would never hurt her, and she needs to do that in a credible way. And then try to talk about the time period that she was with her, and that it doesn't match up with these supposed intentional injuries that this doctor and other witnesses are going to be talking about. And that's up for the jury to believe. Look, this is a tragic case.
It absolutely is.
This doctor who just testified talked about there was actual trauma to this girl. So somehow, in a non-accidental way, she was killed if this medical testimony is to be believed. So the defense has to say this was someone else who did it.
And look, this is another day of testimony explaining that these injuries are no accident. Let's go back live into court.
In the case, one relating to the hemorrhages you saw in the eye. And you have to say yes or no.
Yes.
Okay. And then the second one about an ultimate diagnosis being abusive head trauma, correct?
Yes.
All right. And you would agree with me that those opinions are medical opinions,
Yes.
and they do not identify a perpetrator in this case.
Correct.
That's not your role.
Correct.
You're a doctor, correct?
Yes.
And you evaluate the medical evidence.
Yes.
I was going to ask you about the mechanism of injury. I understood abusive head trauma to be a medical diagnosis that indicates a viewpoint that there was an abusive act that caused the hemorrhaging that was unknown to medical evidence. Is that your understanding of abusive head trauma?
I'm sorry, say that again?
No, it's a bad question, isn't it? You testified that your diagnosis was abusive head trauma.
Correct.
And then you further testified that it was your belief based on the evidence that the mechanism of injury was shaking.
Correct.
Okay. Are you aware that that is not an opinion shared by the other doctors that the state has called or will call in this case?
I'm not aware of the testimony of the other doctors or what they plan to say.
I'm going to show you, and if I can approach the witness, I'm going to show you what has been marked as State Exhibit 11, and I will proffer to you that this evidence is going to be presented to the jury later today. And take a look at that. And it's the coroner's report in this case.
Yes, I've reviewed it.
Okay, you have reviewed it? Okay.
Yes.
And it has the coroner's evaluation of internal injuries and its examination, and external, but also has conclusions, correct? On the front of on page 1. Take a look at those, and when you're done, I'm going to show them to the jury.
And I would object to that.
Let's approach. I can just cross off.
Okay, so what did you make of right now where we're in the second chapter of this testimony?
Right. Well, so the defense lawyer is trying to show that there's other medical testimony, even from the prosecution, that's inconsistent with this witness's testimony. And this witness correctly said, I'm not aware of other witnesses' testimony. I can only talk to you about what I can testify about, which is proper because a witness isn't supposed to be evaluating other people's testimony usually. So the defense is obviously going to flesh this out. They just presented the coroner's report, and they'll probably try to show there's inconsistent medical conclusions about the injuries here, but we'll see how credible that is the way they develop it.
And where do you think the defense would go with their witnesses, besides calling the defendant, who we see there, that's a live feed right there of the defendant in court? I mean, what kind of witnesses should they call?
They might want to call an expert of their own who can look at the retina scan and other medical records and say that they would draw a different expert conclusion about whether this was intentionally inflicted abuse or whether it could be caused by an accident. And remember, they just have to show reasonable doubt. So even if an expert witness on the defense says it's possible that it was an accident, that may be enough for reasonable doubt. Maybe they'll do that. Yeah,
and these idea of two different falls that Hannah might have, she might have one 2 days before, one the day before, two different ways. A fall can be pretty traumatic, but this level of injuries, that's a different question. Or could it be a combination? Falls and maybe something else?
Well, look, 3-year-olds fall all the time. That's just their normal life. They fall, they run, they climb, they fall. So they're always falling. The question is, would a normal 3-year-old's falls amount to this type of injuries? According to this doctor, the answer is no.
And she's been charged with involuntary manslaughter, murder, and 3 counts of child endangerment. What do you make of those charges?
Well, those are the appropriate charges. Obviously, the top count is really the serious charge. The endangering counts. There's not going to be consecutive time because it's really one action or one series of actions against this victim here. So the defendant, though, is facing a tremendous amount of prison time if she's convicted.
Yeah, I want to analyze those charges a little bit because it might not be exactly what people are thinking about, especially in terms of the murder charge and how it connects. But this is a very serious case where we're trying to understand exactly what happened. It's also fascinating to see the defendant in court waiting because this is a really big moment for the defense. We're going to take a break, but when we come back, we're going to jump live into this courtroom. We don't want you to miss any part of the Parton case, and we're also keeping a careful eye on the Jonchuck trial as well. We'll be right back right after this. Welcome back to Law and Crime, everybody. I'm Jesse Weber, joined here by Law and Crime legal analyst Dan Shore, breaking down the biggest trials of the day. Let's get started. So we are also monitoring, I want to let you know, we're carefully monitoring the Jonchuck case out of Florida. This is the trial of a father who's accused of killing his 5-year-old daughter, Phoebe, by allegedly throwing her off a bridge in Tampa, Florida on January 8th, 2015. The defense is not disputing the fact that Jonchuck is the killer, but they are saying that he cannot be held legally responsible because he is in fact insane, or let me rephrase, he was in fact insane at the time of the killing. Now, here's the thing to note. There's been a development in this courtroom. There's a chance this trial may be cut short because their defenses raised the fact that their client may be incompetent to further stand trial. They've been claiming that he's been suffering from hallucinations, delusions, that he's been laughing inappropriately during the course of this trial. He's been evaluated yesterday by a medical expert who deemed him competent, but a second evaluation will be conducted, and actually right around this time, a second evaluation will be conducted, and we will learn hopefully shortly whether or not this defendant is in fact competent to stand trial and whether the trial will continue. We'll obviously let you know. Right now, though, we are live in a different trial. This is the Ohio case of Lindsay Parton, the babysitter who's accused of killing 3-year-old Hannah Weshy. She's been accused of beating this girl and basically engaging in a sadistic pattern of child abuse. So this girl suffered many injuries. The defense is claiming that Parton never injured this girl, that the injuries sustained by this 3-year-old were a result of her either falling on 2 separate occasions before she ultimately died, or perhaps somebody else inflicted these injuries. On the stand right now is Dr. Michael Young. He's a pediatric ophthalmologist who said, in his opinion, the injuries sustained by Hannah were the result of child abuse. Let's go back live.
But what I was getting at is Dr. Dean did an autopsy, correct?
Correct.
It was done on March 19th, correct?
Yes.
It was done after your eye exam of Hannah, correct?
Yes.
All right. The statement you gave to the jury was that you suspect that the mechanism of injury was shaking, correct?
Correct.
I pointed out to you that Dr. Dean has a statement about blunt impacts, which is different to a layperson than shaking,
Yes.
right? The literature indicates that when evaluating for shaken baby syndrome, the absence of blunt impacts is good evidence that shaking might have caused the injuries here, correct?
Not necessarily.
Okay. The existence of blunt impacts to the head is evidence that is the cause of the hematomas and the hemorrhaging, correct?
No, not necessarily.
Okay. Doctor, you're aware that Dr. Dean, are you aware that Dr. Dean doesn't address shaking as a mechanism in her report?
I'm not sure. Yes, I am aware of that, but I'm not aware of, coroners being empowered or routinely, not empowered, or routinely indicating that.
You're aware that on 3/20/18, are you aware that Dr. Dean called law enforcement because of her new finding that Hannah had a severe raised and swollen bruise on the back of her head?
I was not aware of that.
Okay. A severe raised and swollen bruise.
Objection, Your Honor. You just asked the question.
I'm going to ask a different question.
Let me hear the entirety of the question, then we'll address it.
Do you agree with me that a severe raised and swollen bruise is a blunt impact?
It might be. I'm not qualified, I don't think, to actually interpret the coroner's finding. I have not had a history of correlating what coroners find and what the clinician evaluates and correlating those two. That's not been part of my training.
Okay. You have your notes there?
Which ones? My notes.
From Children's Medical
Yes.
Hospital.
Yes.
And maybe you know, maybe you don't, but are you aware that the records, the total number of records in the Children's Medical Hospital records exceed 4,500 pages? Do you know that?
I didn't know that, but it wouldn't surprise me. Yes.
Okay. And I assume you didn't go through them all.
I did not.
Okay. And the notes that you added to that 4,500 plus collection of medical notes is about 15 pages, correct?
Yes,
And you have it in front of you,
yes,
no more, no less. Correct?
correct. This is all I remember putting it.
Right. And nowhere in that, those notes, do you address shaking or the mechanism of injury, correct?
Correct.
All right. And sometime in the summer of 2018, you engaged in some email correspondence with Kelly Highland.
Yes,
And you're aware that that email was supplied to me as part of the exchange of documents in this case.
I understood that they were discoverable, yes. but
Okay.
I didn't know that they were actually
All right.
sent to you.
And you were asked to either agree or disagree with the following statement. Hannah Weshy's injuries are consistent with abusive head trauma. Correct?
I haven't reviewed my emails with her, but
Okay,
it's
I can show
possible.
it to you.
Okay.
You want to do one more? Or is it?
No, I don't.
I need a sticker. I got one right here. And I'm going to label this one-page email as Defense Exhibit B, I think. Can I approach the witness? I'm not going to publish it. Yeah. I need a marker to write B. All right. We'll do it later.
Okay, let's break down what's happening right now. Again, I'm here with Dan Schur, who's also a managing director at Ankara. Dan, defense has some work to do here. I mean, this witness, who's highly qualified, it appears to be, said that in his opinion, it appears to be, abusive head trauma.
Mm-hmm.
That's his diagnosis. What are they trying to dissect here? What are they trying to make the point of?
Well, one key thing they're doing, which is a good tactic against any expert, is to say you didn't review everything, because it's very hard to review every single document. So he's saying, I believe it was 4,500 pages of medical records, and he's saying, well, you didn't review it all. Why is that important? Because then in closing arguments, he could say, look, he gave his opinion, but he didn't even review all the records. And this is a common tactic. It's hard to, as they say, out-expert an expert. If you're an expert at something, I can't really convince you that you're wrong because you're the expert and I'm just a lawyer, but I can say, hey, you didn't review everything, so therefore your conclusion is faulty.
Are they also saying that he's making statements today in court that are not in the report?
Right, he's going beyond his report. And again, that's typical. You don't write down every single thought in a report because it's hard to contain your full analysis, but you try to document as much as possible. So he could say, you're changing your story a little bit, you didn't review everything. And again, as we keep saying, they're trying to establish reasonable doubt. So they could say, look, you can't conclude beyond a reasonable doubt that it's intentional force just because this doctor who didn't review everything and changed some of his, or didn't include all of his conclusions in writing.
I think we can jump back in. Yeah, let's jump back in and we'll hear this cross-examination.
I think you testified that you've not been an independent expert for third parties.
Correct.
All right. You've only been an expert witness for the people that you've treated or seen.
Yes.
Okay. How many times have you been an expert witness?
In that sense, the second sense that you just described?
Yes.
I've only been in a trial once. I have done depositions less than 5-6 times, I would guess, or written letters on behalf of various legal counsel.
All right. And before I move on and forget, did you ever tell any of the agents here at the state here, the prosecutors, about your shaking mechanism hypothesis? Did it ever come out of your mouth?
I believe so.
Okay.
It's possible that it was assumed underlying our discussions. but I don't remember the verbatim details of every conversation we've had. I have supplied documents and some studies and things like that, where that's been listed as the presumed mechanism.
Okay, so you've had conversations with them?
Mm-hmm.
You don't recollect using the term shading?
I don't recall specifically doing. I may have.
You may have, but you don't know.
I don't know for sure.
There would be no documentation to either support or undermine that premise, that idea that you communicated this to them.
Well, so
Is there a document?
no, I think I did talk to them about that, about the possibility of this. We talked about the various names for this. I mean, non-accidental trauma. It may not have been like a detailed discussion, but I think we may have talked about the fact that there are various names for this entity: abusive head trauma. It's gone through evolution of terminology, non-accidental trauma, shaken baby syndrome, things like that. So the very fact that we may even have mentioned that phrase, shaken baby syndrome, would suggest that that's part of the thought of the what's going on here.
Okay. Did you ever put it to writing?
I don't think so. I haven't reviewed all my emails, but I don't think I actually wrote that. But again, it's in some of the information packets about this. I think I sent a consensus statement of various medical societies, and that may have gone through. So if you want to look for the word shaking, it probably was in something that I sent.
To them?
Yeah, I think so.
Well, Dr. Michael Young's been on for quite some time. We're going to take a quick break. When we come back, we're going to be live in Ohio, and we're keeping also a very careful eye on Florida as well, the Jonchuck case. We'll be right back, right here on Law and Crime. Parton case out of Ohio, and the injuries sustained by 3-year-old Hannah Weshi are being examined this morning. Dr. Michael Young still on the stand. He's now under cross-examination about his findings. Again, earlier he testified that he believed the injuries sustained by this young girl were a result of abusive head trauma. That's very different than an accident. Let's go back live and we'll hear what the defense is trying to do.
The shaking mechanism, they don't have impact, and they still have the eye findings.
Right, okay. So the eye findings are immaterial to the death and the mechanism of death in this case?
Correct. I mean, somebody could die or they may not die, and there are different age groups in which they may or may not be more vulnerable to and it also depends on what happened to them. I mean, there are patients who are just simply shaken, but they weren't actually struck on some object or other. So what I can say is that we see lots of patients who have severe head trauma from various other mechanisms, and they don't get this kind of hemorrhage.
Say the last part again?
They don't get this kind of hemorrhage.
Beginning, before that.
So we see lots of patients who have head trauma for other reasons, known reasons, witness reasons, like a motor vehicle accident or something like that, where it can be pretty severe, and we don't see these kinds of hemorrhages.
Right. But again, just so I'm clear, the eye injury that you're responsible for, that you evaluated here, likely has you cannot connect to death or the cause of death in this case.
No, well, I try to say it a little bit more clearly. Shaking resulting in hemorrhages like this, this extensive hemorrhages are usually associated with some type of severe brain injury. Whether there's any impact involved, you can still get swelling of the brain if there's no impact of the head on actual blunt objects. Now, it's possible that maybe the patient strikes their head on their chest and back and forth and things like that as a part of the shaking and may not reach this level of trauma that you observed by the coroner. But one can still get brain injury from that. Whether it actually reaches the point of causing death, is variable in terms of the patient. Many of them have cognitive damage even if they survive.
Isn't the fact of the matter that children's hospital professionals like you just missed the bruising, the back of the head, the impacts to the back of the head? It's true, right?
Well, I don't examine the back of the head.
Okay.
As to whether the other doctors miss it, I can't say. I mean, it's.
Well, you had 4,500 pages of medical records from Children's Hospital.
Well, I would say that there's an inconsistency, obviously, but if there are, were they asked to search every square inch of the body, I don't know what the protocol is on that side.
Okay. Well, I mean, you got a patient that is presented to Children's Hospital with head injuries, correct? So an evaluation of the head would seem to be what the role of the medical professionals would be.
Right. So I agree that there's an inconsistency, and they may have missed it, but I don't know for sure. I mean, I don't know if what children said in response to them, was this part of the neurosurgery process? It hasn't been rolled out. Was there something else that caused a problem that they didn't find on initial evaluation? I just can't speak to that.
And that substantial bruising to the back of the head that was discovered by Dr. Dean on March the 20th is immaterial to your opinions and assessment.
Correct.
You've given two opinions here again, the hemorrhaging and then the abusive head trauma, correct?
Yes.
That's the extent of your opinions.
Yes.
No more, no less.
Yes.
Oh, I know what I wanted to ask you. This has been engraved, right? I'm going to show you this picture. Jamie, can we get that back on? Yes, let me show you the picture. I'm going to show you what's been labeled State Exhibit 46. Take a look at that while I ask my colleagues.
Now, Dan, I want to just break down what the defense is doing here. Are they also getting the sense that, yes, he provided opinions today, but it's kind of limited in what his opinions were? I mean, really, the crux of his testimony was about the eye.
Right. He's talking about there was abusive head trauma that caused the injuries to the eye. And one of the defense points is that we don't know what kind of abuse led to that abusive head trauma. Could have been shaking, could have been a strike, blunt force trauma. And the witness is acknowledging, yeah, I don't know how it was necessarily caused, but I know that it was some kind of abusive trauma, which isn't an accidental fall. So the defense is saying, well, that's not really clear. Certainly that'll be part of their argument that we don't know how these injuries are caused. But sometimes that's the nature of injuries, that you could tell it's not through an accident, that some kind of intentional act had to have caused these injuries, but we don't know exactly what intentional act that was.
You would think a case where a babysitter is on trial for the death of a 3-year-old that was in her care would seem pretty straightforward and a pretty easy case to prove. But is this an easy case for the prosecution?
No, these cases are difficult. I've seen these cases when I was in the DA's office, and they're difficult because you don't know exactly how the injury was caused, especially if the only person there besides the deceased child is giving one version of events that's maybe inconsistent with the evidence. But then how do you show what actually did happen? If someone says, well, there was an accidental fall, or I have no idea how this injury was caused, and yet there's abusive head trauma, according to the doctor, if no one else was witnessing it, how do you show what actually caused these injuries?
Especially since the defense will also be casting the blame out on other people, including, it seems, the father. I mean, why was he bringing his daughter to Parton with a blanket over her head and a hood? Seems a little suspicious.
Right, and that's how these cases proceed, that the defendant usually says, I didn't cause these injuries. I don't know how they were caused. It was either maybe an accident, maybe someone else did it, but I didn't intentionally cause these injuries.
Yeah, I think we can jump back into court. Yeah, let's do that right now. We'll listen more what's going on.
I mean, you would agree with me that it would be problematic for a witness to identify bruises in a photograph where that witness doesn't know who took the picture, when the picture was taken, or where the picture was taken.
Yes, I would agree with that.
And that's because the way the body operates, the way bruises are, blood shifts over time.
It might be that I just simply missed it in terms of my documentation of the eyelid, because that wasn't the critical part of my evaluation.
And it wasn't just part. I mean, what you're describing here wasn't in your notes, correct?
Correct. I agree that it's inconsistent with my notes. I only made a note of the upper eyelid ecchymosis, so I have to explain either the bottom part as being things that were so mild that it wasn't obvious at the time. I don't know what time this was taken. I certainly would willing to own that I may not have described it quite perfectly, but I did make note of the fact that there were ecchymosis of the eyelids.
And to be careful and not to mislead, you don't want to say a particular mark on the body was what you saw when you don't have a memory of it. Yes,
Yeah, I didn't take a picture of it. Correct.
And because marks in the body can change over time.
They can.
I think I'm done, but I want to approach real quick.
Okay, so it appears this witness is finishing up. We're going to take a break on our end, and when we come back, we'll be live in Ohio, and maybe we'll have a new witness on the stand, and we'll talk about the next chapter of the Lindsay Parton case. Stay tuned. We'll be right back. As we wait to jump back alive into the Lindsay Parton case, and Dr. Michael Young, a pediatric ophthalmologist, has been on for this whole morning so far, first under direct and now under cross. Let's just analyze some other aspects of this case. Dan, one of the things that I'm going to be waiting for is what the prosecution mentioned in their opening statement, that the defendant allegedly gave inconsistent statements to law enforcement. In fact, they claim that she at one point said that she admitted to uppercutting Hannah multiple times and poking her in the chest. The defense is saying she never injured Hannah. What's going on?
Well, if they can actually prove that she made these inconsistent statements, that's going to be a real key part of showing consciousness of guilt. Why would you make inconsistent statements if you weren't guilty? There's also been public reports, excuse me, about maybe the girl here threw ketchup into a toilet, and that it motivated the defense to get angry. That hasn't been put into evidence in any way, but there were some public reports about that.
Right.
So will that come into evidence? How do you establish that motive?
But if that comes forward, if this evidence comes forward, you have law enforcement officers saying, well, you know, the defendant told me X, Y, and Z, and she made this comment on this date. What is the defense attorney supposed to do? Saying, well, you know, she never, when we say uppercut and we say poke, she might have, it was a gentle slap or it was a gentle, is that a way to explain it? I mean, because they never, I'm not sure if they ever said she never hit her, but they said she never injured Hannah. Now, I'm not sure the exact terminology, but maybe that's a way.
That's why the words matter, how it comes into testimony, the reliability of the person who says that she said that. Is that person who's reliable? Can the defense say, well, we never really said that, she never said that? Or do they have to say, well, she said that, but she didn't mean that? Or maybe the words weren't recorded accurately, reported accurately. So we'll have to see what the words are. But certainly if she made statements that she intentionally took actions that might have caused these injuries, that's a major problem for the defendant. But we haven't seen that yet, and the defense will then decide how to dispute it.
Right. And look, the defense is saying that, you know, she's completely innocent. This was maybe a result of falls that happened. You know, all these kinds of evidence, and also that she told the Jason Weshy, this is again the victim's father, about the falls that she sustained and the injuries, saying that she was just doing what a normal babysitter should do. I'll tell you what we want to do right now. Yesterday, we saw the testimony of Dr. Nguyen, who is an ER doctor. This is just audio, there's no visual, but it does provide a better explanation of some of the circumstances of what happened. Take a look.
So on page 6, at the top, it says right side mandibular area with ecchymosis, superficial abrasion, contusion, and the chin appears with contusion, ecchymosis.
Contusion, what does that mean?
Bruising.
Okay. And I think you said ecchymosis, that's also bruising? Mm-hmm. So just two different words, or is there a difference between ecchymosis and contusion?
No, just the same.
Okay. And you also said abrasion. What are you talking about with abrasion? What is an abrasion?
There's a breakage of the skin.
Did you do an evaluation of the eyes of Hannah Weshy?
Yes.
And go ahead.
Oh, sorry.
Go ahead.
Also on page 6.
Also on page 6, thank you.
Right pupil approximately 4 to 5 millimeter, non-reactive. Left pupil approximately 3 to 4 millimeter and sluggishly reactive. The conjunctiva is normal. Periorbital ecchymosis or bruising left, worse than the right, with no crepitus and bilaterally no deformities. Fundus exam showing blood bilaterally.
All right, and we had a lot of medical terms in there, so I just want to make sure that we understand what you're talking about.
Sure.
All right, and when you say right pupil, you're giving a measurement 4 to 5 millimeter, that's the measurement of the pupil?
Correct.
When you say sluggishly reactive, what are you talking about? What do you do to make that measurement or determination?
Reaction to light response.
And so could you explain, just in case there's some of those of us that maybe don't understand what that means or what the eye is supposed to do?
Sure. So in a dark area, the pupil dilates, and you shine a light in there, the pupil will constrict. And that's, so when we shine a light in, we kind of look at how it reacts.
Okay. And so in this instance, with Hannah, did her pupils react when the light was shined in her eye?
Looks, the right did not, the left very slowly.
Okay. And is that abnormal?
So she arrived in the emergency department unresponsive. She wasn't protecting her airway, so made the decision to intubate and put her on the ventilator.
And when you say intubate, what do you do to intubate?
I put a breathing tube down her throat and help her breathe.
Did you administer any other type of treatment or medication?
We gave her medication to facilitate the intubation.
Okay. During intubation, could you have caused any of the injuries that we've previously seen that you circled?
Absolutely not.
Would that have caused any injuries on Hannah during the intubation externally?
No.
Did Hannah ever require CPR while at Fort Hamilton Hospital?
No.
Did you contact any outside hospital for assistance in treatment with Hannah?
Yes.
And who did you contact?
Cincinnati Children's Emergency Department.
And based on that contact, what was your plan of care?
We were to intubate her and set up for a air care transport to their emergency department.
And then did you do that?
Yes.
While at Fort Hamilton Hospital, did you order any additional screening?
Yes.
What did you order?
A CT of her head, her neck, and her face.
As we listen to the testimony of these experts, Dan, the thing that gets to me is the idea here that I think this case is just a battle of experts, right?
Yeah.
Which side will the jury believe? We see that a lot in other kinds of cases, maybe even the insanity case, but this one is all determining about the injuries. This is so injury specific.
It's not entirely a battle of experts. It's definitely a big part of it because there's the question of were these injuries based on intentional force or were they based on an accident? That's one part of it. And then if it was intentional force, who caused it? And that's less of a battle of the experts. Was it this defendant? Was it the girl's father? Was it somebody else? So there's two parts of this case. How were the injuries caused intentionally or not? And if intentionally, who caused them? And certainly the part about whether intentional or not, that's a battle of experts. We saw that with the cross-examination of the last doctor, and I'm sure we'll see that after this, and you'll probably see at least one defense expert.
We keep saying that what the defense is arguing is that Hannah fell, right? I want to just make sure we're clear here. What the defense said in their opening statement is that Hannah took a face plant onto the ground. This was 2 days before she ultimately died. The next day, this is a day before she collapsed, is that Hannah was standing on a toy train and she fell hard. And then it's been alleged that the defendant told Hannah's father about the injuries as well. These seem to be pretty serious injuries, so I can imagine the defense bringing their own kind of experts will be a big move for them.
Yeah, there will be at least one defense expert, and the cross-examination of the last doctor showed that they were focusing on a bruise on the back of her head, that they said the notes from that witness for the prosecution did not observe, and maybe they're going to show that that bruise was with the cause of the death that the prosecution overlooked that, or the doctors who were being called by the prosecution overlooked that. So it's going to be, well, what injury was the cause of death? What was not the cause of death, and maybe just another bruise? Children have bruises. Usually they're not life-threatening. So
Right.
There might be bruises here like almost every young child has from running around that aren't part of what caused her death.
Yeah, well, speaking of experts, let's now play the testimony of Dr. Marguerite Carre. She's a pediatric radiologist talking about the scan of Hannah's brain. What did we learn?
Here is when we see bleeding outside the brain, a couple of the big things, when I see this on a study, I need to quickly get a hold of someone. To me, this baby's brain is being pushed. Someone needs to either do something to relieve that pressure, take off that bleeding, or do something, because as the brain continues to get pushed, it can cause significant problems. The child can have significant hypoxic ischemic injury related to that shift. Bleeding outside of the brain, we see that in different settings. Certainly trauma is going to be the most common thing. When we see bleeding in the subdural location, we think trauma. It's not the only cause of subdural hemorrhage in a child, but it's the most common.
All right, doctor, I'm going to ask, and in my phrasing of this question, I don't want you to express any opinions by any other doctors. However, I do want to know your opinion. And I think we've talked about the causes of this injury. Did you receive any medical history in your evaluation of Hannah Wesche and her slides from any source that would be consistent with the injuries that you were seeing?
I received no information of a significant accidental injury. By the time I signed off the report, I knew that she had significant bruising.
Okay. So you knew she had significant external bruising, is that what you're talking about?
Correct.
That's by the time you signed off on the report?
Correct.
Had you already developed an opinion prior to seeing that external bruising?
Yes.
And you said there was no significant accidental history. What do you mean by significant? What are you talking
Like I
about?
said, so if I see a scan like this, most of the time the child's going to present initially to our trauma bay, and we'll know before the child even gets to our trauma bay that there's a 3-year-old coming in that was involved in a motor vehicle collision or a motor vehicle accident. If a 3-year-old or a 16-month-old comes in with no history, no trauma history, comes to our trauma bay, and I see a scan like this, abusive head injury is going to be one of my main thoughts. I mean, we don't see subdural hemorrhage from a lot of things in the acute setting. Motor vehicle collisions, kids hit by cars, abusive head trauma. I mean, if this were a postoperative patient, a kid with a shunt, I can see subdural collections not infrequently in those kids. But to see it just out of the blue, it's very uncommon from, in children just with routine trauma.
And you say abusive head trauma. What is abusive head trauma?
So someone has caused injuries to the child, and when we talk about head trauma, it can be anywhere from the scalp, the skull, to the actual brain. Some people used to call shaken baby. Shaking is one thought as to how these injuries occur, but unfortunately, lots of injuries can occur in different ways. We have kids who, will find, potentially blood on a wall. You may find kids who are, people say that they threw them across the room, they slammed them down. So any sort of inflicted trauma on a child.
All right, Dan, according to her, Hannah suffered abusive head trauma. She wouldn't have been acting normally. The symptoms of this would have occurred pretty soon after the injuries. This is a blow to the defense.
Absolutely. This is powerful testimony. And also when you view it with the other experts that are testifying for the prosecution, it's really a clear case that these injuries that this girl suffered are not accidental injuries just from a fall here or a fall there, that there had to be some kind of abusive trauma. Was that from shaking? Was that from intentional blows against her? That's unclear, but certainly the idea that she was just playing around and fell and then died, that seems to be not credible when you hear all these prosecution witnesses, if they're believed, and they do come across very knowledgeable, very experienced, very persuasive.
We're going to take a break in a little bit, and when we come back, we're going to play the cross-examination of this witness. And one of the things they talk about is the fact that she provided testimony in another case where her conclusions don't seem to quite match up the same way they did previously about the timing of injuries and symptoms. But before we get to that, the thing that is interesting to me is I heard a flavor of the defense in their argument saying, listen, our client was a babysitter for other people. It's not like a one-time thing. And there's no problems there. How will that or would that help her case?
It doesn't really help your case. That's, if you're accused of rape and you say, well, I didn't rape all these other women who are out there, or I'm charged with pickpocketing and I didn't pickpocket these other people on the streets, that usually is not a good defense to just say, well, I didn't do it to other people, so I didn't do it here.
It's something.
Right.
It's something for them to do.
Right.
I'll tell you what. So let's take a break now. When we come back, we're going to play the cross-examination of the witness you just heard. You're not going to want to miss it. Stay tuned here on Law and Crime. We'll be right back. Welcome back, everybody. We're in a break right now in the Lindsay Parton case out of Ohio. We're also keeping a careful eye on the Jonchuck case out of Florida. Whether or not that trial will still continue is up in the air, depending upon whether a psychologist will determine if the defendant's actually competent to remain in trial. That's a whole separate question. We'll talk about that in a second. But before we jump back live in Parton, we're dissecting some testimony from yesterday that we really think you should listen to. We just played you the testimony of Dr. Marguerite Correa. She is a pediatric radiologist who, after doing a scan of Hannah Weshy's brain, determined that she suffered abusive head trauma. Not an accident, abusive head trauma. And that some of the symptoms of this would be that Hannah wouldn't be behaving like she normally would. Now, under cross-examination, the defense had issues with this, and they poked at some holes in her theory. Take a look.
In December of 2018, when you wrote this opinion letter, around that time, had you discussed with law enforcement, including the prosecutor's office here, a specific time frame that they understood for this case?
We had discussed, because we had sat down as a group and discussed this case, yes.
Okay. And at that point in time, what did you discuss so that you had a state of mind, so you had an understanding as to what the time frame was for Hannah being in the presence of the babysitter in this particular case?
My discussion has been relatively similar in that when those injuries occurred, from that point on, the child would not have been normal. And so,
Okay, go on.
when was the child last normal?
Okay. My question to you was, did you discuss and review evidence about the amount of time that Hannah spent with the babysitter in this particular case?
I know it was a very brief period. I don't know specifics necessarily.
The question, you don't answer my questions. Did you discuss it first? Did you discuss it?
I mean, I have been in discussions, yes.
Who did you discuss it with?
I've been with the prosecutors. I've been with the child abuse team.
Okay. When you discussed it, what information?
I have since met with, I think Kathy Makaroff was there at the time. I don't remember if the coroner, I think the coroner was actually there. The medical examiner was actually there when we discussed the case. So
who was there to discuss it?
To be honest, I'm sorry, I don't remember, but we have met several times about this case.
Okay. What on March the 13th, 2018? That's the child abuse day.
Yes.
All right. And then many times after that?
We've met a couple times since then, which is not unusual for us when we're
After
looking
March
at
the
these
13th,
cases.
2018, what is the next time that you remember meeting with other people on the timeline in this case?
I don't know a specific,
Okay.
to be honest.
Who, the next time, who was present?
Like I said, I remember meeting with Kelly Hiley, and I think the coroner was there, or the medical examiner was there, and Kathy Makaroff, who was also involved in the case. I don't remember if the detective was there.
Right. Did you review either a report or a phone dump that demarcated the time that Hannah was present at the babysitter's house?
I was provided information that, yes, she was there a very short period of time between when she was dropped off.
So you were supplied information to look at? Yeah?
I was given that information, yes.
What were you given? Why are you being so coy? What were you given?
I was given that the father dropped the child off, the child was taken by the babysitter, and that dad was driving to work and received a phone call very shortly thereafter that Hannah had collapsed, something along those lines.
And who told you this?
To be honest, it's in the medical record, I believe, in Epic. It's Kelly Hiley probably has supplied that to me, the prosecutors.
Some medical records? Were you given any other documentation? How about a police report?
I don't usually see a police
How
report.
about text messages?
No.
How about a phone log?
No, we've already
What time was
discussed that.
911 called?
I don't know.
What time was Hannah's father called?
I don't know.
What time was Hannah dropped off?
I don't know. I think she was dropped off about an hour before she went to Fort Hamilton, or within the hour, I was told at some point.
So you had all this information in your head about the timeline and the importance of the time, and you write me a report that says rapidly. You use that term, that adverb, rapidly, knowing the critical aspect of timing in this case, and that's what you choose to use, right? Yes?
Yes.
And for the first time in the history of this case, on cross-examination, you bring up a unit of time within seconds. Yes?
Yes.
All right.
All right, so we've seen throughout this case that the cross-examination is getting a little heated at times, but the timeline's important here, right, Dan? I mean, when did she receive the injuries? When was she exhibiting symptoms of not acting normally?
Right.
Because if you believe the defense, she was brought over to Parton's house, and a minute later, she collapses. So what do you make of everything that we just saw?
Right, so she's saying that if this injury happened a while ago, the girl wouldn't have been normal for that amount of time. And the defense is going after her saying, well, you're talking about the timeline being important, but you don't have all the details in your knowledge, such as 911 call time, other details. And as we talked about before, that's a common tack to go after experts, because often in a case they've reviewed their own expert analysis, but they haven't reviewed all the police reports. They don't know the details of every witness testifying. So you could say to them as a cross-examiner, hey, you don't know this, you don't know that, you haven't reviewed everything. And then you could argue to the jury, look, this person is basing their conclusions on incomplete information, so therefore don't believe it.
They also went after her past. They took out a transcript from an old case where she testified where that time frame between the injury and the symptoms wasn't as precise as she had just explained. And then she finally concluded, if I'm understanding her testimony correctly, that just looking at the brain scans, she couldn't tell the timing of the injury. Let's just get into the charges here. They're a little different than what people would expect, especially the murder charge. Can you help elaborate? She's charged with murder, involuntary manslaughter, and 3 counts of what you could call child endangerment.
Right, and the murder charge is not intentional murder, so they're not alleging that she intended to kill this girl. They're saying that she committed some other violent felony, endangering, and that violence led to the death, that it was a proximate cause, led to the death, and that's why it's murder. It's almost kind of felony murder case. So they're not saying that this babysitter intentionally killed this victim here, but that her intentional violent acts led to the death.
In other words, the defense's only option is to say that she never laid a hand on this girl, that this was a complete accident, or somebody else hurt this girl.
Or that she did lay a hand on her. What she did physically did not lead to the death, that there was some other intervening act, someone else took an action, or some other fall that led to her dying, but that her physical actions, even if intentional, although I'm sure she'll not say there's no intentional act, it didn't lead to her death.
Dan, one more question. I know our time together is coming to an end. What kind of jury would you want if you were the defense attorney?
Well, you want a jury that's going to be skeptical of experts, people who may not just believe what they're told, people who may think outside the box. I think someone who's just going to hear experts and believe them is going to be likely to reach a conclusion favorable to the prosecution. And you want at least one juror to have a doubt about what the experts are trying to convince the jury of. Dan Shore, Law and Crime legal analyst and managing director at Anchor. Thanks so much for coming on. It's always great talking with you, Jesse.
Thank you. All right, everybody, we're going to take a break. When we come back, a lot to talk about here on Law and Crime. Stay tuned. We'll be right back. back to Law and Crime, everybody. I'm Jesse Weber. A lot to talk about today. Let's keep going. So we're going to be live again in 2 trials today. We were just live this morning in the Ohio v. Lindsay Parton case. What a trial this is. A babysitter who's on trial for the murder, involuntary manslaughter, and also 3 counts of child endangerment in connection with the death of 3-year-old Hannah Weshy. Today and yesterday has been a whole discussion about the injuries sustained by this young girl. The prosecution is saying that this is a clear case of child abuse. The defense is saying not so fast, that our client never touched this girl, never injured this girl, that she might have suffered all of these injuries as a result of falling on 2 occasions prior to her death, or maybe somebody else contributed to these injuries. It's an interesting back and forth between the experts, and maybe we'll get a chance to talk about it a little bit later on. In a few minutes, we're going to talk more about what's been going on in the Jonchuck case. We are in a waiting pattern to see if this trial will even continue. It's about a father who's accused of killing his daughter by allegedly throwing her off a bridge in 2015. Now's a question of whether or not the defendant is even competent to continue with trial. His defense counsel has said that he has been exhibiting extremely odd behavior, talking about hallucinations, that he's been laughing at inappropriate times. We're going to have a chance to talk a little bit more about that in a second. But before we do, there's always so much else that's happening in the country, and here's a special report about what else is trending. Take a look.
This is today's true crime update from Law&Crime. Los Angeles police named a suspect in the shooting death of rapper Nipsey Hussle. At a news conference Tuesday, LAPD said they believe the suspect, Eric Holder, was in a personal dispute with the rapper. Hussle was shot outside a clothing store he owned in South Los Angeles. He had been investing in businesses in the impoverished neighborhood he grew up in. Holder remains at large, and police are asking for the public's help in finding him. A Connecticut man acquitted of raping a college student is suing his accuser and the university she attended. Alfonso Reed filed a lawsuit against Sacred Heart University. He claims the university and his accuser made false and misleading statements that ruined his reputation and caused him injury. Last year, a different Sacred Heart University student was found guilty of making a false rape claim against 2 football players. The 2 players are now suing the college as well. A 40-year-old man is in jail accused of stabbing a 19-year-old woman in a Taco Bell parking lot because she turned him down for a date. According to Archdale, North Carolina police, after being rebuffed, the suspect followed the victim and her family from church to Taco Bell and tried to run them over but missed. After crashing into a utility pole, he attacked the victim with a knife until her family was able to intervene and keep him down until police arrived. The victim was later airlifted to the hospital where she remains in stable condition. This is today's True Crime Update. I'm Rachel Stockman for the Law&Crime Network.
Thanks, Rachel. But that's not the only update we have for you. We also have an update for you in Operation Varsity Blues. You know, this whole big college admissions scandal that rocked the world several weeks ago? Well, we have an update for you, and it regards actresses Felicity Huffman and Lori Loughlin, as well as Lori Loughlin's husband. These 3, as well as several other defendants, are expected to appear in federal court today in Boston in this probe. It's going to be a very interesting part 1 of this case. You'll recall that Loughlin and Huffman are charged with committing mail fraud and honest services mail fraud in connection with allegedly bribing and cheating their children's way into colleges. It's a really incredible case when you listen to the details of it. We believe that investigators will continue to charge other people in connection with this scheme, and we're going to cover as much as we can here on Law and Crime. We don't believe cameras will be allowed in that courtroom, but we will provide updates for you about what happens today. It's unclear if they're going to be entering pleas today. I don't believe they are, but if something should happen, we'll make sure to let you know. But again, a big update out of Hollywood. And now we also want to switch gears and focus on our main live trial. We're talking about the Jonchuck case. This is a very interesting development. I haven't seen anything quite like this. And how ironic is it? We were covering the past few days where the defense has been putting on experts to discuss the fact that Jonchuck, they want to claim, was insane at the time he allegedly threw his daughter off the bridge. And while this was going on, the defense attorneys spoke to the judge and said, well, He's been exhibiting some really odd behavior. You see him there laughing in court. He has been engaging in hallucinations, seeing things that just haven't been happening. And there's a question about whether or not he's even competent to stand trial. Now, yesterday, there was the judge ordered a evaluation of him. This psychologist determined, after about a half hour of evaluating Jonchuck, that he was competent to stand trial, but there's going to be a second evaluation. I believe it's being conducted as we speak, and we're keeping a careful eye on the courtroom feed to see if there's some update about what's going to be happening here. Let's just go rewind to yesterday when Jonchuck's defense counsel spoke with the judge about this, and we'll see if this trial continues. Take a look.
So he also today has been displaying inappropriate laughter, which is a symptom that we have come to recognize sometimes when he does appear to be losing touch. And when we questioned him about that, specifically, you just seem like your mood is more elevated today, or, is that right? Is there anything going on? He had indicated that it was because we were making him laugh and that we were saying funny things to him, specifically Ms. McNeil and myself, and I have only had conversation with him this morning, unfortunately. Basically, good morning, everything go okay in the jail last night? Did you get all your medications? I haven't even had a chance to really speak to him. And additionally, Ms. McNeil had indicated that she also had not had really any small talk with Mr. Jonchuck today. He is insisting that he's completely fine and that he's not hallucinating. These are things that have actually happened. So he is insisting that everything is fine. We certainly have some concerns at this point.
Did you have any prior concerns about his competency that you didn't express to the court?
No, the first time we became, all of these things are concerning.
Correct.
However, taken each individual one, after the 18th, we believed it seemed to, there was a comment that had happened that had happened Sunday night. We've checked with him every day since. Is there anything unusual in the jail? Is everything going fine? He indicated that it was. Then he had made the one comment during jury selection, I believe it was on Tuesday. After that week went fairly smoothly. We did, however, hire a confidential expert to meet with him to kind of get a baseline in case there was an issue. That doctor indicated to us that it was apparent that there was some trauma associated with Dr. Lazaro, but that he was competent at the time. And so we...
Can I ask you when that occurred?
Which part?
The confidential expert?
Friday morning we met before we started trial. Before we started jury selection. So the first, that Friday of jury selection, I went over there before we started trial.
Okay.
And then last week, I think it was Tuesday or Wednesday that we started having the discussion about the expert sitting in, but he became very fixated on who was going to be present in the courtroom, so he had just asked a lot of questions but hadn't expressed nothing that suggested he was having hallucinations or anything. The two comments with the jurors Friday evening concerned us. We had attempted to have our confidential go evaluate him again yesterday, and due to his status was unable to, and the jail staff at the time, they were unable to let him out to do a confidential evaluation. So our concern arose for the most part if he's hearing statements that the witness testifying is saying that he's not saying. I think that's different than if he has paranoid beliefs about the jurors. I don't know if it's different, I guess, from a professional standpoint, but to us it seemed, there's not really a lot we can do about the jurors, but if you're not able to understand the testimony in your own trial or believe that things are being said that aren't, certainly that would...
Dr. Otto's the only witness he seems to have confusion about what he said? that the only witness?
I feel like there was one other instance that I can't recall, Judge, so I don't want to say that for certain, but we've racked our brains and that I think Mr. Williams and I both have like a residual feeling that there was one other instance, but we can't think of what it was.
Well,
And then the conversation in the back
I understand.
furthered the concern.
Even though Dr. Otto did not identify Dr. Lazaro by her name of Emily or make reference to her in any regard, I think we can all see why one might be led there as opposed to just picking something out of the sky. Do you have any questions? Dr. Perman?
No, Your Honor.
Dr. Perman?
I do not.
Does the state want to put anything else on the record?
No, Judge, we understand it usually has to be under the rule written, but obviously they can't do it written in a trial. We appreciate them putting on the record everything that they can provide for the doctor to make that determination.
Okay.
And we'll go from here and see what happens.
All right, so you're going to look at him?
Yes, Your Honor.
And so I will formally appoint you to examine Mr. Jonchuck for purposes of competency to continue on with his trial.
Yes, Your Honor.
Thank you.
Yes.
This was from yesterday. We're in a waiting pattern right now, waiting to see what the determination is from the second evaluation and if Mr. Jonchuck is competent to stand trial. This is a really fascinating moment. We're going to have to wait and see. Interesting, though, because what we were discussing in the actual content of the trial was the insanity defense, and the defense was in the middle of their defense. They called Dr. Scott Mockless, who was a psychologist in the beginning of their case, and under his professional opinion, after evaluating the defendant, he believes John Jonchuck was insane at the time of the killing. This is a huge moment for the defense. Let's play that testimony for you earlier in the trial.
I saw him on July 14th, 2017, and July 24th, 2017.
And was there a specific purpose to those evaluations?
That was to pursue my evaluation on his mental state at the time of the offense, or whether he was insane at the time.
All right. So when you conduct that type of evaluation, so now we're talking about the evaluation that occurred in July of 2017 and continued on. What do you do? What do you need?
Well, what I need for when I do conduct a forensic evaluation is I look at police records, I look at mental health records, medical records, I interview the defendant, I gather information from collaterals, which are family members, people who know them, and when I feel that it is important to conduct psychological testing as well.
Okay. Now, you said that you gather information from collaterals. What's that mean?
Collaterals are interviews with family members, with friends, with people who knew him at, depending upon the type of evaluation, but certainly in an insanity evaluation, around the time of the offense, and could speak about his mental functioning at the time.
So it's to gather information that those people would provide?
Yes.
Does it have to be in person?
No.
What are some other ways that you can gather that information?
That information can be obtained through police reports. It can be obtained through depositions.
And in this case, did you obtain information from the collateral sources from the police reports?
Yes.
Did you obtain information from the collateral sources from depositions?
Yes.
Did an evaluation to offer an opinion in court as to whether Mr. Jonchuck was not guilty by reason of insanity. Have you formed that opinion?
Yes.
And what is that opinion?
That he was insane at the time of the offense.
What we've talked about so far, for the most part, is what part of that two-prong analysis
Well, first of all, that the first prong is that he has a mental disorder, and he has a very severe mental disorder. He has a mental disorder that causes him to be out of touch with reality.
I'd now like you to talk to us about the second part of your opinion, which allows you to form the opinion of not guilty by reason of insanity. Can you tell us what that part of your opinion is?
That he did not know the wrongfulness of his behaviors.
Do you have any slides that document your opinion as to that?
Yes.
Show those to us, please.
As we've gone along, I've mentioned some of these things which indicate that he did not know the wrongfulness of his act. But I'll highlight them. First of all, he was experiencing hallucinations and delusions at the time. He was out of touch with reality. He was experiencing very psychotic symptoms. And some of these symptoms included that the world was coming to an end. He had hallucinations and delusions of him and Phoebe being possessed by demons.
Now, this one here, did you get this from, this is not just John telling you this, other people told you this, correct?
Correct. He had the irrational belief that he and Phoebe had to die in order to save the world. These were all the thoughts that he was experiencing that night, as well as he had the hallucinations about the demons for at least a week. He had the hallucinations and delusions about the world coming to an end and that he and Phoebe had to die around the time.
Now, at this point in the trial, we were saying, hey, looks like a pretty strong case for insanity, maybe more than any of the ones we've seen, especially in light of the comments made by the defendant. You heard it himself. I mean, why would he say these things? Why would he do these things unless he was actually insane? Well, that's what we thought until this witness was cross-examined by the state. If you haven't seen this, this is a brilliant cross-examination that we're going to play for you after our next break. Now, it should be noted, I'm keeping a careful eye on the courtroom feed in the Jonchuck case to determine whether or not we have a decision on if this trial will continue, whether or not the defendant is actually competent to stand trial. An evaluation is currently being done. We'll get some answers at some point today. That's some B-roll of the defendant laughing, what seems to be uncontrollably or inappropriately during trial. That was one of the points contended by his defense counsel. So we got a lot to cover, but when we come back, we're going to play for you that cross-examination of Dr. Scott Miles. We'll be right back. we're live right now in the Lindsay Parton case. It just started up. This is the babysitter accused of killing 3-year-old Hannah Weshi. What's going on right now is there is an objection from the defense in response to the witness who was just on the stand earlier, Dr. Michael Young. You recall that in his opinion, he believes the injuries that he looked at were a result of abusive head trauma. Now, one of the things he had mentioned is that he thought it could have been a result of shaking. But as the defense has pointed out in his notes, he never mentioned shaking. They're arguing that this concept was first brought up in this trial. So they're having a big issue with this. They're taking it up with the judge. The state has said it's always the opinion that there's been abusive head trauma, and shaking is just one of the ways this may have occurred. Let's go back live and we'll learn more.
All-encompassing use of terminology that can cover certain actions, including but not limited to shaking. And that's where this issue becomes problematic. The court understands that all of the records, all of the reports that have been provided in relation to this particular witness have been consistent and stated abusive head trauma, which, as I've just stated, is a broader category. To my understanding and knowledge, neither party has come into this courtroom this morning understanding or expecting that Dr. Young was going to testify as to one of the specific mechanisms that's encompassed in that terminology. If I'm stating anything inaccurate, just somebody raise your hand and correct me, that's fine. That is my understanding of the situation. When the doctor goes from preparing reports and summaries and expert opinions and whatever that include this generalized category, and then for the first time narrows it down to one of a specified categories of behavior encompassed in that terminology, nobody has any notice of it. The court recognizes the state probably even suffered some prejudice as well in terms of how they prepared their case and arguments, whatever. But certainly the court understands the defense. If they had known that the ophthalmologist was going to come in and offer that specific opinion, they would have at least looked into the possibility of getting their own expert to refute that finding, and they have not had opportunity to do such. So what the court is inclined to do after considering the matter, after also finding, and I think that the defense is not alluding to any bad faith, I'm not finding any bad faith, I have to look for the least restrictive measure of correcting this situation. I am going to give a limiting instruction to the jury that they cannot consider the testimony of the doctor in regards to the shaking specific mechanism that was provided on the stand. And so the record is clear, and I'll allow both attorneys to hear both sides, but when I say both attorneys, I mean all attorneys, to hear this for potential input. My intention is to instruct the jury, quote, "Ladies and gentlemen, you have heard testimony from Dr. Young. You are to disregard any testimony from the witness that the causation of the retinal injuries was from a shaking mechanism and that any potential resulting brain injuries therefrom. This is due to testimony that was not presented to either the state or the defense prior to trial." So that is what the court intends on instructing the jury. And again, the case law is well established that the court has to presume the jury will follow that instruction. So either side wish to be heard on the proposed instruction.
Nothing on behalf of the state.
No, sir. All right.
Go ahead.
No, if you have something to add, go ahead.
Well, I just going forward, I think you're going to instruct, and then I don't know who the next witness is. I just for scheduling, I'd like everybody to know that I understand there's two other doctors, Dr. Dean, and then who will be a substantial witness, and then a treating Children's Hospital doctor who's a fact witness, who I wouldn't spend nearly as much time with. So, and it's almost new.
Well, for scheduling purposes, because we are in the redirect, and I don't know how much redirect recross there's going to be, we'll permit that, obviously, with this particular witness. Then my plan is to recess for lunch. I'm not going to jump into another witness
Your
before
Honor,
we get too long.
I would ask if we could. It is Dr. Chima. It will be very short. I think we can get him in around 20 minutes. I really do, because he's not on it. He's just a fact witness. I just hate to have him sitting out here for that long, especially if they're away from the hospital when they're here, and I just hate to do that if we could.
So is this something that we could anticipate by quarter after 12 at the latest,
Yes.
approximately, we could be finished with?
I think so, but I didn't know what I was going to say to Dr. Young, you know what I mean? So here we are.
I do.
I remember that conversation. Yeah. All right, we will, then I'll anticipate on doing that. If for some reason it appears as though something's going sideways, we will deal with scheduling. Again, I tried to...
Let's just clarify what happened here. Obviously, Dr. Michael Young testified earlier, but there was an issue with what he testified to. He testified that, in his opinion, the injuries he reviewed were a result of abusive head trauma. No problem there. But he did mention that one of the causes could have been shaking. Now, as the judge just explained, that was never presented to either the state or the defense. So he is going to provide an instruction to the jury when they're called back in, and he is going to say to the jury to disregard any portion of the witness's testimony regarding shaking. So all they really consider is that the injuries he looked at, including especially the eye, were a result of abusive head trauma, but don't think of it as shaking. That's not an issue. We can't talk about that. And it seems to be a very fair ruling. Also a win for the defense right there, because now, again, we know about these injuries, but what exactly happened to Hannah Wesche? That's the question. We're going to take a break. When we come back, I think we'll be live in Ohio, and again, we're keeping a very careful eye on Florida and the Jonchuck case. A lot happening here on Law&Crime today. We'll be right back. And we're back, everybody. Okay, some things to update you about. First, let's talk about the Jonchuck case out of Florida. We've gotten word that the doctor who's currently examining Jonchuck, the defendant, his name is Dr. Richard Cipriano. He's a psychologist. He is the person who is examining whether or not the defendant is mentally competent to continue with trial. As we talked about earlier, his defense counsel made a motion to the court and said, look, there's a problem going on. The defendant has been exhibiting signs of hallucinations. He's been laughing erratically. We want to get him checked out, see if he understands what's happening at trial. There was one evaluation done yesterday. That psychologist determined that he was mentally fit. The judge ordered a second evaluation. That's currently happening. As soon as we get an update from the court, we'll let you know. We could either continue with trial or it might be a mistrial, and we'll have to see what ultimately happens. Now, I do want to let you know what's been going on right now in our other case out of Ohio, the Lindsay Parton case. This is the babysitter who's accused of killing 3-year-old Hannah Weshy. We just finished up with the testimony of Dr. Michael Young. Again, this has been a very interesting day with the testimony of this witness, who's a pediatric ophthalmologist, talking about the injury sustained by this young girl, particularly to the eye. In his opinion, he believes this was a cause from abusive head trauma. Not an accident, not a fall, but abuse. Let's go back live. I think we have a new witness on the stand.
And what are your current duties there at Cincinnati Children's?
I am one of the physicians in the pediatric ICU or the intensive care unit, and I take care of critically ill children.
All right. Thank you for doing that. In that capacity, were you working at Cincinnati Children's between March 8th, 2018 and March 18th, 2018?
Yes, I was.
Did you have occasion to come into contact with Hannah Weshy, date of birth 1/11/2015?
I did.
And as a part of your duties there, is it your job to review and understand the procedures that this child has undergone in your care?
Yes, so for all children who are admitted to the intensive care unit, I was the supervising doctor and was responsible for care of this child during the stay in the ICU.
And as part of your duties there, do you also prepare progress notes and documentation of your care of a child?
We do that daily, yes.
All right, if I may approach the witness with State's Exhibit 150.
You may.
Children's Hospital. Thank you. Thank you.
You say 150?
State's Exhibit 150, it will need to be written in. If you want to take a moment to go ahead and flip through those.
Okay, if you're just joining us, this is a live feed into the Lindsay Parton case out of Ohio. Now, she has been charged with multiple counts, including murder, involuntary manslaughter, and 3 counts of endangering children. That's in child endangerment charges in connection with the death of 3-year-old Hannah Weshy. It's been a remarkable back and forth between the prosecution and the defense. This is day 2. We saw opening statements yesterday. The prosecution says that Weshy really is the cause of all these injuries and the death of this 3-year-old girl. They claim that she just got fed up with this young girl, that she was babysitting her and just had enough, and she ultimately inflicted these injuries. The defense is saying no, that their client never injured this girl, she never harmed this girl, that these injuries could have been caused by something else. One of the 2 points that they contend is that 2 days before Hannah ultimately died or, collapsed and EMTs were called, that she fell and she took a really hard fall. The day before this, she also tripped over a toy and fell, and perhaps those injuries were caused from that. The defense also pointed to the fact that this young girl's father brought Hannah to Parton's house with a blanket over her head as well as a hood zipped up, which is suspicious. Why would he do that unless something else was going on? It's an interesting back and forth. We're going to go back live into the court right now.
In coming into contact with Hannah, were you aware of any procedures that she had received, any procedures that she had undergone, I guess is probably the better way to say it, at Cincinnati Children's?
So prior to me taking over her care in the hospital, she was She had come to us from an outside hospital, and
I don't want to kind of get into what information you have, but just specific any procedures that occurred at Cincinnati Children's. So any surgical procedure that you're...
So from when I took over her care, all the surgical procedures had already been done.
All right.
So when I took care of her, at that point, the surgical procedures had been done, and from when I took care of her onwards, there were no new surgical procedures performed.
All right. And when did you take over care?
I took care of her on the 9th of March,
And did you... 2018, thank you.
Yes.
And how long did that care continue?
So it was for a week.
In your care, did Hannah ever regain consciousness?
No, she did not regain consciousness.
Did her condition change in your care?
Her neurologic condition continued to deteriorate under my care, and that was what changed predominantly.
Doctor, can you tell us whether or not there was ever a determination of brain death in this case?
There was a determination of brain death in this case, and that was what was performed ultimately that led to her death.
Do you recall on what day the condition progressed or changed significantly in your care?
I'd have to look at the records, but it was about 3 days into her being in the hospital, it became clear to us that we would not be able to reverse the processes or even temporize what was going on in her brain. And at that time, we started thinking about doing a formal assessment of her brain by doing what we call a brain death examination. And so it was about 2 or 3 days into her course at Children's Hospital that it became very clear that this may go down the path of brain death.
Now, did that brain death evaluation then occur 3 days into her care?
No, it could not occur 3 days into it because for us to do a brain death examination, the patient has to have no medications in the system that would actually blunt or sort of cloud the neurologic exam. And she had gotten a lot of medications to induce a coma to help her brain and the pressure in her brain. And the levels of one of those medications was too high, and that precluded us doing a brain death examination.
So when ultimately were you able to do the brain death examination?
So I don't remember the exact date, but it was done. I had finished my week, and I had passed it on to my partner, who had taken the case over, and we were just waiting for those levels of the drug to come down to a level where we would be able to do it. And that was done the day she was pronounced, the day it was done. And so when the level came down, we were able to do it.
During your care of Hannah Weshy, were you able to see visible external injuries on her?
So while in the intensive care unit, we children are kept pretty still, and what I was able to observe was some bruising that was notable on her upper chest. And I didn't really turn her much because we were in a medically induced coma, and she was so fragile at that state. So we don't like to move patients a whole lot, and so didn't really look at her back a whole lot. But definitely in the front, when I used to examine her every day, we didn't notice bruising.
Oh. And could any of the care that Hannah received within the ICU have caused external injury to her?
No.
And why not? How do you know that?
Because children who have had sustained very severe brain injury, we keep them very, very still.
It goes beyond observations and what I did and is now analysis or assessment. It exceeds effectiveness.
That's perfect.
As we listen to this ICU doctor who was tasked with trying to save this young girl, it just shows the tragedy of all this and how sad this case ultimately is. Let's take a quick break, and when we come back, we're going to be live in Ohio. We'll be right back.
If you're over 50, did you know you could be taking advantage of everything AARP has to offer right now? Join today for just $12. Find out what 37 million AARP members already know. Benefits start instantly.
It's AARP.
Are you joining AARP?
Actually, I just did.
But is it worth it?
I enrolled at 7:02, saved on concert tickets at 8:10, read a great article on investing at 9, found a sweet travel deal at 10:15. I used the caregiver finder for my dad, and done. Discounted movie tickets.
Call or go to getaarp.org to join today for just $12, and your second membership is free. And get instant access to discounts on eye care, prescriptions, savings on travel, dining, and deals from top retailers. So many ways to save. Instant resources, tools, and tips to help manage your money, maximize your health, and so much more. AARP is mobile. Get alerts to savings and events near you. And AARP is the largest advocacy group for people over 50. Your voice will be heard.
I love the local retail discounts. AARP absolutely pays for itself.
I'm nowhere near ready to retire, and AARP has been a tremendous resource for that.
I get reliable financial tools and tips.
And we check out the hotels, the dining. AARP saves us a lot of money.
Join today for just $12 for your first year. That includes a second membership free. Plus, you get the award-winning AARP The Magazine.
I love the magazine. Everything in there applies to me.
Benefits for both memberships start instantly. So call or click to join AARP today, and you get this travel bag and AARP The Magazine free.
Call 1-800-411-8550. That's 1-800-411-8550.
Or go to getaarp.org.
Okay, welcome back, everybody. While we were in that break, we were live in the Lindsay Parton case out of Ohio. They just went to a lunch break, but let's just tell you what happened while there was that break going on. On the stand was an ICU physician. Sad testimony, talking about how there was nothing really more they could do for 3-year-old Hannah Weshy when she was in this state and brought to the hospital. Some other things to note is that he indicated any of the injuries sustained by this girl were not a result of him or his team. They took very special care to make sure that she was not, injured in any which way. They're very delicate with her. He did observe some physical injuries to her chest, but again, didn't move her very much. More of just things that we needed to learn. The defense questioned him under cross-examination about that he's not there to provide an opinion of any sort. It was basically a straightforward examination, very short. What we do believe is that when trial resumes in about an hour at 12:45 p.m. Eastern Standard Time, the medical examiner will take the stand. That's going to be a big moment for both sides to determine the cause of death, and we're going to get even more into the injuries sustained by this young girl. This case is just filled with expert testimony, maybe more so than any other kind of case. We'll talk about that. We're also keeping a careful eye, by the way, on Jonchuck. We're waiting to see the results of his examination determine if he's mentally competent to continue on with trial. As we talked about earlier, the man who's accused of killing his daughter by allegedly throwing her off a bridge, his defense counsel made a motion yesterday to the judge saying that there's a big issue here, that he has been exhibiting very odd behavior, namely that he's been laughing during court, as you just saw in this clip. He has been exhibiting signs of hallucinations. There's a strong chance that he might not be competent anymore to stand trial. At one point, you'll recall at the very beginning of this case, he was deemed not mentally fit to stand trial. Then he was evaluated again, and he was determined to be mentally competent. So, interesting case, especially since this is a insanity defense trial nonetheless. We'll talk more about it once we get more information. In the meantime, we're focusing on the Parton case, and let's take a step back and talk about some testimony, again, about an expert. Dr. Marguerite Carre, she's a radiologist who did brain scans of Hannah Weshy. Let's see what she determined.
In December of 2018, when you wrote this opinion letter, around that time, had you discussed with law enforcement, including the prosecutor's office here, a specific time frame that they understood for this case?
We had discussed, because we had sat down as a group and discussed this case, yes.
Okay. And at that point in time, what did you discuss so that you had a state of mind, so you had an understanding as to what the time frame was for Hannah being in the presence of the babysitter in this particular case?
My discussion has been relatively similar in that when those injuries occurred, from that point on, the child would not have been normal. And so,
okay, go on.
When was the child last normal?
Okay. My question to you was, did you discuss and review evidence about the amount of time that Hannah spent with the babysitter in this particular case?
I know it was a very brief period. I don't know specifics necessarily.
The question, you don't answer my questions. Did you discuss it first? Did you discuss it?
I mean, I have been in discussions, yes.
Who did you discuss it with?
I've been with the prosecutors. I've been with the child abuse team.
Okay. When you discussed it, what information?
I have since met with, I think Kathy Makaroff was there at the time. I don't remember if the coroner. I think the coroner was actually there. The medical examiner was actually there when we discussed the case. So
who was there to discuss it?
To be honest, I'm sorry, I don't remember, but we have met several times about this case.
Okay. Well, on March the 13th, 2018, that's the child abuse day.
Yes.
All right. And then many times after that?
We've met a couple times since then, which is not unusual for us when we're looking
after March
at these
the 13th,
cases.
2018, what is the next time that you remember meeting with other people on the timeline in this case?
I don't know the specific.
Okay.
To be honest.
The next time who was present?
Like I said, I remember meeting with Kelly Hiley, and I think the coroner was there, or the medical examiner was there, and Kathy Makaroff, who was also involved in the case. I don't remember if the detective was there.
And did you review either a report or a phone dump that demarcated the time that Hannah was present at the babysitter's house? Did you?
I was provided information that, yes, she was there a very short period of time
Right.
between when she was dropped off.
So you were supplied information to look at? Yeah?
I was given that information, yes.
What were you given? Why are you being so coy? What were you given?
I was given that the father dropped the child off, the child was taken by the babysitter, and the dad was driving to work and received a phone call very shortly thereafter that Hannah had collapsed, something along those lines.
And who told you this?
To be honest, it's in the medical record, I believe, in Epic. It's Kelly Hiley probably has supplied that to me, the prosecutors.
So medical records? Were you given any other documentation? How about a police report?
I don't usually see a police
How
report.
about text messages?
No.
How about a phone log?
No, we've already
What time was
discussed that.
911 called?
I don't know.
What time was Hannah's father called?
I don't know.
What time was Hannah dropped off?
I don't know. I think she was dropped off about an hour before she went to Fort Hamilton, or within the hour, I was told at some point.
So you had all this information in your head about the timeline and the importance of the time, and you write me a report that says rapidly. You use that term, that adverb, rapidly, knowing the critical aspect of timing in this case, and that's what you choose to use, right? Yes?
Yes.
And for the first time in the history of this case, on cross-examination, you bring up a unit of time within seconds. Yes?
Yes.
All right.
This was an interesting moment in court. So Dr. Marguerite Correa said that, in her opinion, this child suffered abusive head trauma. We keep talking about this, that this wasn't some sort of accident. This wasn't some sort of fall. The defense is claiming, though, that this young girl fell 2 times in the last 2 days before she ultimately was rushed to the hospital. But, she said that this girl suffered abusive head trauma and that from that trauma, she would not have been behaving normally. Well, you can see that the timeline of this is very important. When did she get these injuries and when did she start behaving not like Hannah? That's the important part. Now, what the defense was trying to point out in their cross-examination, and also pointing out to her testifying in a prior case, that she's not that exact in determining, well, how soon after these injuries does someone exhibit these symptoms? Well, what she said is at the end, she couldn't tell the exact timing of the injury. That's a big point. There's been a lot of big points from the experts in this case, including what we saw Dr. Michael Young as well, that again, abusive head trauma, but the jury was instructed to disregard everything about shaking. Lot to cover here on Law and Crime. I am signing off. Bob Bianchi is signing in, and he's going to guide you through the next chapter of these 2 cases we're covering. We'll be right back.
Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it from 12 to 3. Got some great stuff on the table. Of course, some great guests. No one's covering it like the Law&Crime Network, gavel to gavel. As you guys who have been watching this know, this Lindsay Parton case, another case, there she is with a little girl dead. I mean, these are such sad cases, but they're very, very intriguing, and we're going to be covering that case, as you guys would know. Look at that little sweetheart in that little outfit there. We'll be covering that case, gavel to gavel. Babysitter alleged to have committed murder with respect to her during a course of time she was babysitting. And Jonchuck, man, this case is getting insane. Jonchuck is not just pleading insanity, but in the middle of these proceedings, his competency is now coming into question. You folks may remember it took a long time to get him to trial because the court had declared that he wasn't competent to assist his defense during the course of the trial. And right in the middle of the trial, the judge has ordered that psychologists and psychiatrists evaluate him to determine whether he's able to proceed to assist in his defense. We'll talk a little later on about the difference between an insanity defense and competency to stand trial, often confused, but very different legal principles. But first, we have a true crime update. We'll be back on the other end.
This is today's true crime update from Law&Crime. Los Angeles police named a suspect in the shooting death of rapper Nipsey Hussle. At a news conference Tuesday, LAPD said they believe the suspect, Eric Holder, was in a personal dispute with the rapper. Hussle was shot outside a clothing store he owned in South Los Angeles. He had been investing in businesses in the impoverished neighborhood he grew up in. Holder remains at large, and police are asking for the public's help in finding him. A Connecticut man acquitted of raping a college student is suing his accuser and the university she attended. Alfonso Reed filed a lawsuit against Sacred Heart University. He claims the university and his accuser made false and misleading statements that ruined his reputation and caused him injury. Last year, a different Sacred Heart University student was found guilty of making a false rape claim against 2 football players. The 2 players are now suing the college as well. A 40-year-old man is in jail accused of stabbing a 19-year-old woman in a Taco Bell parking lot because she turned him down for a date. According to Archdale, North Carolina police, after being rebuffed, the suspect followed the victim and her family from church to Taco Bell and tried to run them over but missed. After crashing into a utility pole, he attacked the victim with a knife until her family was able to intervene and keep him down until police arrived. The victim was later airlifted to the hospital where she remains in stable condition. This is today's True Crime Update. I'm Rachel Stockman for the Law&Crime Network.
Oh, great. Thank you very much. Listen, probably the most important show that during the time that I host can only be described as my introduction of my next guest, the infamous hashtag 4041, having shot all those great points as an all-state basketball player in high school, an all-state DOJ guy for 30 years, the Gene Rossi War Room. Gene, welcome back to the show, Law&Crime analyst.
I can't wait for Final Four to start.
Well, listen, I mean, why watch that when you can watch some of these fascinating trials, Gene? And just as a little sidebar, today a very important event is happening in the college cheating scandal. You may recall that case. It was just a breathtaking, wide scandal that ensnared this Huffman, I forget her first name, and Lori Loughlin, and they're accused of basically paying money. Huffman in the amount of $15,000 to fake SAT scores, Loughlin in the amount of $500,000 in bribes to get their 2 daughters in via a fake process where she was being, the kids were being told they were on the crew team, and therefore they were able to get these kind of scholarships or bumps, if you will, into the school. They were each undeserving kids. They did not deserve to be there. They took seats away from kids that should have been there. Gene, I was just recently doing a hit on this subject, and you know what I looked at them like? I called both of these people and the other parents that participated in this armed robbers. Armed robbers. A little different than what we normally think of armed robbers. Arms were filled with cash, and that cash was used to give to people illegally to rob deserving students of their positions in the school. I think it's pretty disgusting, and as the head prosecutor, if this case came across my desk, I'd be looking to make a message that the rich and the privileged cannot get away with taking things from those who work hard to earn things. I'd be looking for prison time. What are your thoughts, Gene?
I'd be looking for a lot of prison time. And Bob, you know what I'm talking about. We had a lot of cases presented to us involving victims and violence and, murder, rape, things like that. And of course, your heart just bleeds. But whenever I got a fraud case with categorical, just pure greed and deceit by people who had no reason to act like that, I would go for the hammer, because they have no reason to do what they did. They don't need the money. They don't have a unsettled home. They have all the gifts in the world, and they still cheated. That really offended me to no end.
What a message, because for those of us who have grown up with the right ethics and morals, our parents tell us, you don't have the grades, you didn't make the team, then move on to something else. You don't deserve to be there, as opposed to mommy and daddy spending money. Gene, I know you're a literary guy. I know you're a food aficionado. I know you're essentially the Renaissance man in the legal profession and here at the Law&Crime Network. This reminds me of Dante's Inferno, where the lowest rung of hell, all the way down before you get to Satan himself, is the person who commits fraud, the person who takes advantage of those other people. With all the crimes we can think of, these kids, as you've indicated, had everything in life. And I, as far as a justice question, ask you, what about those disenfranchised kids that we prosecute? What about those kids that don't have money, don't have access, don't have great education, kids who didn't know any better, that got caught up in minor crimes and go to jail? I can't, as a prosecutor, put those people in jail and let these folks who had everything slide.
Absolutely. That's why I had so much passion and determination in prosecuting people like this. Now, to be fair, we're both criminal defense attorneys. They're assumed and presumed innocent, but the allegations in that U.S. Attorney Office's indictment in Boston, they're pretty bad.
Yeah.
And I got to tell you, it's going to be a tough case if they go to trial.
Of course, they are all presumed innocent, but how the mighty can fall, pride coming before the fall. I don't know, Gene. I think they got a pretty solid case from what we've read so far, but we will wait and see. Now, the guys in the chat room, and if you're not in the chat room, you're making a mistake, because you can watch how they were laughing at me before, because I didn't say Jonchuck's name the right way. They're right. But nevertheless, we are covering that trial, and some very fascinating things occurred, as I said to you before, with regard to his competency right in the middle of a case. I can tell you as a prosecutor, this is the last thing you want. You certainly don't want a mistrial because you can't proceed. And moreover, there's an automatic appellate issue that's being created right now if the court does proceed with the trial. It's going to be pretty fascinating. Let's listen to the defense's arguments and discussion to the court about what it was they were observing that led them to the conclusion something's not right with this guy.
So he also today has been displaying inappropriate laughter, which is a symptom that we have come to recognize sometimes when he does appear to be losing touch. And when we questioned him about that, specifically, you just seem like your mood is more elevated today, is that right? Is there anything going on? He had indicated that it was because we were making him laugh and that we were saying funny things to him, specifically Ms. McNeil and myself, and I have only had conversation with him this morning, unfortunately. Basically, good morning, everything go okay in the jail last night? Did you get all your medications? I haven't even had a chance to really speak to him. And additionally, Ms. McNeil had indicated that she also had not had really any small talk with Mr. Jonchuck today. He is insisting that he's completely fine and that he's not hallucinating. These are things that have actually happened. So he is insisting that everything is fine. We certainly have some concerns at this point.
Did you have any prior concerns about his competency that you didn't express to the court?
No, the first time we became, well, all of these things are concerning.
Correct.
However, taken each individual one, after the 18th, we believed it seemed to, there was a comment that had happened Sunday night. We've checked with him every day since. Is there anything unusual in the jail? Is everything going fine? He indicated that it was. Then he had made the one comment during jury selection, I believe it was on Tuesday. After that week went fairly smoothly. We did, however, hire a confidential expert to meet with him to kind of get a baseline in case there was an issue. That doctor indicated to us that it was apparent that there was some trauma associated with Dr. Lazaro, but that he was competent at the time. And so we...
Can I ask you when that occurred?
Which part?
The confidential expert?
Friday morning we met before we started trial. Before we started jury selection. So the first, like that Friday of jury selection, I went over there before we started trial.
Okay.
And then last week, I think it was Tuesday or Wednesday that we started having the discussion about the expert sitting in, but he became very fixated on who was going to be present in the courtroom, so he had just asked a lot of questions but hadn't expressed nothing that suggested he was having hallucinations or anything. The two comments with the jurors Friday evening concerned us. We had attempted to have our confidential go evaluate him again yesterday, and due to his status was unable to, and the jail staff at the time, they were unable to let him out to do a confidential evaluation. So our concern arose for the most part if he's hearing statements that the witness testifying is saying that he's not saying. I think that's different than if he has paranoid beliefs about the jurors. I don't know if it's different, I guess, from a professional standpoint, but to us it seemed, there's not really a lot we can do about the jurors, but if you're not able to understand the testimony in your own trial or believe that things are being said that aren't, certainly that was...
Dr. Otto's the only witness he seemed to have confusion about what he said? The only witness? I
feel like there was one other instance that I can't recall, Judge, so I don't want to say that for certain, but we've racked our brains and that I think Mr. Williams and I both have like a residual feeling that there was one other instance, but we can't think of what it was. And then the conversation in the back
I understand.
Furthered the concern.
Even though Dr. Otto did not identify Dr. Lazaro by her name of Emily or make reference to her in any regard, I think we can all see why one might be led there as opposed to just picking something out of the sky. Do you have any questions? Dr. Perman?
No, Your Honor.
Dr. Perman?
I do not.
Does the state want to put anything else on the record?
No, Judge, we understand that it usually has to be under the rule written, but obviously they can't do it written in an open trial. We appreciate them putting it on the record, everything that they can provide for the doctor to make that determination.
Okay.
And we'll go from here and see what happens.
All right, so you're going to look at him?
Yes, Your Honor.
Now, so I will formally appoint you to examine Mr. Jonchuck for purposes of competency to continue on with his trial.
Yes, Your Honor.
Thank you.
Yes.
All right, welcome back. So, Gene, essentially these defense attorneys, they seem pretty well documented, talking about it's not just one singular thing, it's a number of things, including the previous incompetency issues, him thinking that the witnesses are saying things that they're not saying, it caused them to actually get a confidential and independent investigation both before the trial and then during the trial. There's inappropriate laughter. Now, I know the audience here may think that lawyers kind of like this may be a little game playing or whatever, but I can tell you by the way it was being presented, these lawyers did this as they should to protect themselves as professionals as well as the client's rights. And they're telling the court, we have concerns as to whether he's understanding the witness's testimony. That's a bad place for the defense attorneys to be.
Oh, absolutely. And I want to educate our wonderful listeners and viewers. Under a case called Cooper versus Oklahoma in 1996, the Supreme Court said that competency is a burden on the defendant by preponderance. And I don't know what Florida, I don't know if they follow that, but anytime a defense attorney has questions about the competency of their client, they have to raise that because the law presumes that a defendant is competent to stand trial. So basketball, the ball is in the defense attorney's court to show that he's not competent. They did a great job. She laid the record, and then we'll see where it goes.
We have a fascinating case, as always, on the Law&Crime Network. Hey, Gene, we got to do a little business here, but we're going to come back on the other end of the break with more Law&Crime. Welcome back. My name is Bob Bianchi. I'll be with you to 3. We're still in the Jonchuck case. Let me give you a little recap what went on. State is done with its case. It's rested. there's no question about the fact that he committed this crime. The only question is whether or not there's a viable insanity defense. The defense is putting on very compelling information, both through fact witnesses, as we call them, that's mom and dad, and even the police officers who testified on behalf of the defense in the case. But you need psychological testimony in order to show that there was a mental disease or defect that he had, that he suffered under the mental disease or defect at the time of the incident, and that it basically robbed him of his ability to know the difference between right or wrong, which goes to the heart of could he form an intent to commit a crime, which is required under the law. If in fact the jury finds by, I believe it's clear and convincing evidence in Florida, that he was insane at the time of the incident, well, he may get off on what we call a not guilty by reason of insanity. The key so far by the defense is, in my estimation, gone in really well. But now the monkey wrench happens where he may be declared incompetent in the middle of this case, which could potentially cause a mistrial. We're waiting to see what happens as the court-appointed medical experts take a look at him. But let's switch back. Let's assume that he is declared competent and this case goes forward. Well, then we go into the witnesses as to the insanity defense, and that is whether or not he could have appreciated the rightfulness or wrongfulness of acts because he was under a mental disease or defect. So we will look at right now the defense medical expert under cross-examination by the prosecution. Let's go to it.
In September of 2014, he also heard the voices getting louder, right?
That's when they initiated, he reported.
Now, he reported to you that in September of 2014, when the voices were getting louder, he noticed that when he was using drugs, that had an effect on the voices getting louder, right?
That increased it, yes.
That increased it. What kind of drugs was he taking in September of 2014 when the voices were increased?
He reported that he was smoking spice.
And what else?
He used crystal meth a couple of times.
Now, as a doctor who's conducting your sanity evaluation, you have to eliminate drug use on the date of offense, correct?
Yes.
Because if he's on drugs when he commits the murder, then he's not insane, right?
That is what case law says, yes.
So if he is on drugs when he commits the murder, and that is what is causing the psychosis, if the drugs are causing the psychosis, then he's not insane, correct?
Then I would not give that opinion.
That he is insane, right?
That he is insane.
And in this particular case, you're relying on the defendant telling you that he was not using drugs on the date of offense, correct?
I'm using his self-report as well as the reports of family members who observed him that month, as well as individuals who evaluated him at that time, police officers, as well as attorney and priest reports that indicated that he did not appear to be under the influence of alcohol or drugs.
And as far as mental illness goes, you agree that mental illness does not, or the presence of mental illness doesn't automatically equal insanity, right?
Correct.
There's a second prong to that, correct?
Yes.
You have to, in order to be insane, not understand the nature of your actions, the consequences, right?
Correct.
Or you don't understand the wrongfulness of your actions, correct?
Correct.
Okay. In your opinion, did Mr. Jonchuck, the defendant in this case, know what he was doing when he dropped Phoebe off the bridge?
Factually, the information that I have is that he did have that information. He did have that appreciation.
So you believe he understood that he was killing Phoebe by throwing her off the bridge?
No, for that there is mixed messages, so that because there's mixed information about that, I'm not able to give an opinion.
So you don't know if he understood the consequences or not. Is that your opinion?
Correct.
And when you interviewed him, he wasn't displaying psychotic symptoms during your interview, right?
He was not displaying hallucinations or delusions, although his thinking was disorganized and that he was very distractible. He was jumping from topic to topic, and I had to keep him on track in order to get the information in which I needed.
But no delusions or hallucinations, right?
Correct.
We're talking about psychotic symptoms.
Let him finish. Okay, thank you. You can finish now.
Correct. He was being medicated at the time, and medications were addressing his hallucinations and delusions.
Now, prior to your interview with him, you're aware that the defendant had read the police reports in this case, correct?
Objection.
Improper. Overruled.
I don't know exactly what information he obtained about the offense.
Wow, Gene, there's a lot to unpack here, okay? So let's give our audience a little bit of an idea of what's preceded us. There's all this crazy behavior, if you will, for lack of a better expression, with going to the priest and looking for a baptism, talking about exorcism. He went to his family law attorney who actually called 911, and eventually he had contact with the police who did a Baker Act on him to see if he was a danger to himself or others. This is just preceding the incident. The mother was saying, testified that he was acting odd. And when he went to jail, I found this very interesting. A psychologist that evaluated him in jail, as well as somebody who treated him, said that he was suffering from psychotic features and schizoaffective disorder. So those are great facts for the defense. So the defense puts this expert on, though, Gene, and you got to be really careful with the expert, because the prosecutor, I think, fell into it. Good for them, because he's basically saying, the expert, I'm not able to form an opinion as to whether he understood the consequences. And so our audience knows, last point before you respond, Gene, it's the defense's burden here to prove by clear and convincing evidence that he did not understand the consequences. Thoughts?
And in my closing or rebuttal, I would hold up the jury instruction that says that the defendant has the burden by clear and convincing. And I said, members of the jury, their own expert couldn't give you an opinion about whether he understood the consequences.
Yeah,
that was very bad for the defense.
Yes, surprising, because this is something that as a defense lawyer, or any lawyer for that matter, you would have to know. This is the ultimate conclusion. This is the ultimate question. This is the big gee right here, the big shot that you need to ask this question to get an answer to. And either they knew they were going to get a wobbly answer from that witness, which is not good for them, or they didn't know, which is even worse, because you should. So the facts to me are really strong, Gene. But the expert's opinion, at least thus far, is not so well. But we got to go to break. I'm sorry, John. I'm being told that Jonchuck is live. Let's go.
Speaking loud and clear voice to the court, just move right close to the mic.
Is it your request? Would you like to ask him the questions?
Congratulations for the defense. Tell us your name, please, sir.
Second.
Could you tell us your name, please?
Okay. Richard Cipriano. I'm a psychologist licensed in the state of Florida. Cipriano.
And did you interview Jonchuck Jr. this morning?
Yes, sir, I did.
And what caused you to conduct that interview?
I received a court order from the judge to do a competency evaluation of Mr. Jonchuck.
And did you do that have you just recently completed that evaluation?
Yes.
And could you tell us what your opinion is regarding Mr. Jonchuck's competence to proceed?
He's competent to proceed.
No other questions, Judge?
Any questions from the state?
No, Judge.
Okay. Defense, are you stipulating pursuant to Dr. Foreman and Dr. Cipriano that he's competent to stand trial?
Judge, we can't stipulate that he's competent. We will stipulate that the court can make your ruling based upon the reports of Dr. Foreman and Dr. Cipriano.
Okay. You want to say anything, Mr. Bowen?
Well, if that's the case, before Your Honor makes a ruling, I would ask Dr. Cipriano if he could just put on the record the facts and details
That's
upon
a
which
good
he's
idea.
making his opinion.
You want to question him about that?
I think that he could just put on the record why he's formed his opinion in the 6 criteria without necessarily be questioning him. I think he could.
Okay, that's Jonchuck breaking news. Second expert hired by the court independently have said that Jonchuck is competent to continue with this trial. Boy, this is going to be an unbelievable case. We got to go to a break. Stay tuned, because I have a funny feeling sparks are still going to fly.
Law and Media-ite?
Law and Media-ite.
There is a legal or law point of view in what's happening in the news.
5 devices in the building that
sends its people.
Okay, welcome back to the Law and Crime Network. One of my favorite segments, you guys know it, is Media-ite, where they do the intersection of a lot of politics and law. We have Aidan McLaughlin with us, the managing editor. Listen, Aidan, I'm looking at one of the articles you got here. It says 8 shocking revelations from New York Times investigation into Rupert Murdoch's media empire and Fox News that supposedly, based on your reporting of this article, it did massive investigation as to the ins and outs and permutations and wherefores and whereofs and but-fors of the family and the disputes going on within the family, both as to how the agency should run and where is this leading us? What's it about? Where's it leading us to? This is pretty significant news.
Right. So basically, it's a massive New York Times Magazine investigation that looks at Rupert Murdoch, who is the founder of Fox News, looks at his media empire, his family, and it's worth remembering that they've just gone through a sort of reshuffling of leadership. Rupert Murdoch is getting older. He suffered an injury last year. And so Lachlan Murdoch, his son, has taken control of Fox Corporation, which is the new company that is the parent company of Fox News. So this piece looks at the sort of shifting power dynamics within the empire. And there's one very fascinating angle of it that I think I want to emphasize. And that's what delves into the Murdoch's failed attempts to buy out Sky, which is a broadcast company based in the UK, and it owns Sky News. And basically, they made 2 attempts to buy out Sky. One was in 2011, and it ended up being scuttled when they ran into a phone hacking scandal, and they had to withdraw their bid. Now, James Murdoch, who is another one of Rupert's sons, made a second attempt to acquire Sky in 2016, and that also was scuttled. And it was actually scuttled because of Fox News, which is the Times' new reporting on this. And they basically say that while James was trying to pull off this acquisition of Sky, there was the big sexual harassment scandal at Fox News that broke, that involved Bill O'Reilly. And James was so terrified that this would scuttle his Sky News bid that's the reason why he ousted Bill O'Reilly so quickly and gave him a little $25 million package to leave Fox News. So basically, that wasn't enough to secure the acquisition of Sky, and it was eventually scuttled as well. British regulators also cited the coverage that Sean Hannity did of the Seth Rich conspiracy theory as reasons to scuttle this bid and say that the Murdochs didn't deserve to have such control over British media, which would have been allowed to them if they had acquired Sky.
Aidan, something to pick up on your point that I found fascinating in the article as well was just what you recited with regard to Sky in England. But they then made an acquisition of Sky or started it in Australia, which they were allowed to do. And based on this article, it's indicating that it has now become a beast, if you will, where all politicians, it's going off the hook. It's the go-to thing for politicians. Explain, what is the difference there, if you know, between the British reaction to this and the Australian reaction to this? And where are the brothers with respect to what the programming should look like?
Right. So Sky, their attempts to buy Sky is a massive British-based telecoms company, and they own Sky News in the UK, and they also own Sky News in Australia. Now, after the Murdochs failed to acquire Sky, the telecom company, they were successfully bought out Sky News in Australia, which is a network like any other. And basically, it always used to be a sort of politically neutral, straight news network. And after the Murdochs bought it, there was a noticeable shift in the prime time towards being more opinionated, more conservative. And it was basically run by Lachlan Murdoch, who's the more conservative of the 2 sons. And since becoming more sort of opinionated in the way that Fox News was, its ratings have soared. And it's actually become a destination for Australian politicians to go on and to try and push policy. And so it's become a political reckoning force, which is basically what happened with Fox News in the United States. And so it's following a similar trend, and it doesn't seem to have unnerved regulators in the same way that the attempted acquisition of Sky did in England.
We talk a lot in the United States about the relationship between the president and Fox News, and there's a lot in this article about Donald Trump actually reaching out Brett Baer was one of the people. Sean Hannity clearly is involved. Tell us where in this article it's telling us the relationship between President Trump and Hannity, both before and after the election, and that incident that happened with Brett Baer where the president actually sent his resume.
Yeah, so we all know that Trump is in very frequent contact with his favorite Fox News hosts. Hannity, he's in regular contact with. He often calls him after his show wraps at 10 p.m. But one really fascinating piece of info from this New York Times piece is that Brett Baer, during the 2016 election, was actually covering the various candidates during the Republican primary. And despite Trump doing quite well in the polls, gave him kind of a low ranking as far as his prospects in the general election. And Stephen Hayes, a Fox News contributor, actually called Donald Trump a clown. And this was when Fox News wasn't really on board with Trump, at least their opinion hosts weren't on board with Trump in the way that they would later become. And Trump actually sent Brett Baer, he faxed Brett Baer a copy of his resume and wrote on it in Sharpie marker, would a clown have accomplished all of this? We don't know what Brett Baer's response to that was, but it's certainly a very, Trumpian thing to do.
Yeah, last question, Aiden, because I found this fascinating too. And I really think this is an insight into the president's mindset. He was being treated very favorably by Hannity and relatively favorable by O'Reilly. In the article, it claims, though, that O'Reilly was a little sharper with him, where he, Donald Trump, perceived Sean Hannity as being kind of like, I think the word was succulent, or, basically placating him and not giving him hardball questions. And that the president actually preferred to be on O'Reilly because it showed his strength, his ability to fight back, as opposed to just getting the softballs, according to this article, that he was getting with Hannity. Amazing insight into him.
Yeah, it's fascinating, actually. I really enjoyed this anecdote from the story. Basically, Hannity, I think Trump really appreciates his loyalty and the fact that he's a hard sort of defender of the president. But when it comes down to interviews, Trump actually kind of revels in being combative. He doesn't like doing interviews with incredibly harsh questioners, but Bill O'Reilly would ask tough questions. It wouldn't just be sort of what Hannity does, which is kind of agreeing with the president and teeing him up to give softball answers to things. Trump liked being challenged a little bit by O'Reilly, and so kind of preferred to show off his punching back style, and that's what O'Reilly afforded him in interviews.
Wow, that's amazing. So, ultimate takeaway from this article that you found, of all the things we discussed, it may have been something we discussed, something we didn't. What was the most fascinating thing for you as a media person in terms of this real machination of stuff with the Murdochs and their split, and Fox and Britain and Fox and Australia and the president? What did you find most fascinating?
Well, I think the most fascinating takeaway, and this is because it's geared towards the future, is that Rupert Murdoch has sort of is leaving control of Fox News to his two sons. James, in turn, left control of Fox News to Lachlan Murdoch. He was sort of pushed out, is now dealing with the family's office, dealing with their ballooning empire and fortune. So now he's left it pretty much to Lachlan, who's the far more conservative son, and he's more interested in Fox News being a very successful media company. And if that means being, pro-Trump for the years that Trump is in office, he's on board with that. So I think you'll consider to see Fox News standing by its opinion hosts and sort of promoting like incendiary commentary and really conservative commentary.
Look, just sidebar real quick. The incendiary commentary, the talk show hosts, I get it. Is there an edge towards making sure that the commentary is factual? Is it just kind of maybe the way we spin things, like lawyers can spin things one way or the other? Or is it anything goes?
Well, I don't think it's anything goes. Suzanne Scott, the new CEO of the company, has made a strong effort to keep hosts and contributors and guests in line and stop them from saying things that are offensive or that land the network in controversy. But, you have to remember that the cash cow of Fox News are their opinion hosts. So they're going to protect them, and they're going to make sure that they're allowed to speak to their audience.
Okay, well, Aiden, listen, we always appreciate your insights. Your articles are amazing. For our audience, Mediaite.com is where you can get it all. I go there every morning to get the cutting-edge articles. Thank you so much, Aiden. Have a great day.
Thanks, Bob. You too.
Okay, now we're going to do a little business, and we'll be right back. at the Law&Crime Network. You know, we're also covering the Lindsay Parton case, babysitter accused of killing an infant. Medical testimony is going to be very important, especially that of the radiologist. Let's take a look.
In December of 2018, when you wrote this opinion letter, around that time, had you discussed with law enforcement, including the prosecutor's office here, a specific time frame that they understood for this case?
We had discussed, because we had sat down as a group and discussed this case, yes.
Okay. And at that point in time, what did you discuss so that you had a state of mind, so you had an understanding as to what the time frame was for Hannah being in the presence of the babysitter in this particular case?
My discussion has been relatively similar in that when those injuries occurred, from that point on, the child would not have been normal. And so,
okay, go on.
When was the child last normal?
Okay. My question to you was, did you discuss and review evidence about the amount of time that Hannah spent with the babysitter in this particular case?
I know it was a very brief period. I don't know specifics necessarily.
The question, you don't answer my questions. Did you discuss it first? Did you discuss it?
I mean, I have been in discussions, yes.
Who did you discuss it with?
I've been with the prosecutors. I've been with the child abuse team.
Okay. When you discussed it, what information?
I have since met with, I think Kathy Makaroff was there at the time. I don't remember if the coroner, I think the coroner was actually there. The medical examiner was actually there when we discussed the case. So
who was there to discuss it?
To be honest, I'm sorry, I don't remember, but we have met several times about this case.
Okay. Well, on March the 13th, 2018, that's the child abuse day.
Yes.
All right. And then many times after that?
We've met a couple times since then, which is not unusual for us when we're looking
after March
at
the
these
13th,
cases.
2018, what is the next time that you remember meeting with other people on the timeline in this case?
I don't know a specific.
Okay.
To be honest.
The next time who was present?
Like I said,